Okay, good evening, ladies and gentlemen. I welcome you to this webinar on challenges in adhering to timelines under IBC. We at Resurgent, a investment banking company which provides solutions for the corporates. Today's webinar has been structured to basically discuss the various challenges that the RPs and other stakeholders which they are facing to complete this the entire resolution process or the liquidation process in a timely manner, so that the value which the very objective of the IBC is fulfilled. However, we have seen over these 4 5 years that there are various challenges in meeting those timelines. Apart from the COVID-19 situation which we have faced over last 2 years, the timelines are not being met. We have found that about 73% of the cases in CIRP are having more than 270 days aging. About 69% of the cases where 1 year is the liquidation period given by the code, by the law, 69% cases, more than 69% cases are having an aging of more than 1 year. There are caseload of with the NCLTs. They are unable to cope up what we feel is, but during this discussion, we would like to highlight and we like to get some insight about the issues. With us today are three very prominent speakers. One is Mr. Karan Malhotra. Welcome, Mr. Karan Malhotra. He is an advocate, founding partner of KM Law Offices. He is based out of New Delhi and has a rich experience of more than 5 years in practicing, covering diverse areas of corporate commercial laws. And his forte has been in the field of insolvency, corporate litigation, dispute resolution. He has advised various clients on the entire spectrum of the corporate transactions, including M&As, scheme of arrangement, businesses, asset transfers, mergers, demergers, joint ventures, strategic alliances, etc. He is closely working with corporate debtors, financial and operational creditors, RPs, liquidators, RAs, and commercial creditors, and assisted in navigating these complexities of the code. Welcome, Mr. Karan Malhotra, once again to this webinar.
Thank you for inviting us, and thank you for the initial.
My second speaker is Mr. Nitin Jain. His partner is Agma Law Associates. He is based out of Mumbai and looks after the commercial dispute practice area, having more than a decade of experience. Nitin's principal focus is on commercial disputes, including insolvency, arbitration, high court litigation. Nitin arrives at strategies for handling client litigation with long-term vision and value proposition, ensuring cost effectiveness. His keen eye for litigation has proven result-oriented for various corporate clients. Welcome, Nitin, to this webinar.
Good evening, Mr. Gupta, and good evening to all the participants and panelists.
My other panelist is Ms. Khushbu Vash, a senior director from Alvarez Marsal. She is a turnaround and performance improvement practice in India. She brings 12 years of experience in restructuring and performance improvement. Her primary areas of concentration are operational restructuring, cost rationalization, and interim management. She has worked with clients across a range of industries, including non-banking financial services, airlines, textiles. Ms. Vash leads the thought leadership effort of A&M India and has published multiple white papers. She also advises the government and committees on varied policy matters. Welcome, Ms. Khushbu, on this webinar.
Thank you, Mr. Gupta. Thank you.
As I was telling, there are various issues which are plaguing meeting the timelines. Now, The program agenda for this webinar is there are delays on account of information asymmetry that resolution professionals have contended with. We'll also discussing digitization of IBC platform to speed up the resolution process. They are grappling with promoters holding their firms using legal loopholes, holding the information. There may be some suggestions for improving the recovery rate and resolution timelines. And we may also discuss suggested amendments in the code and regulation for efficient maintenance of the timelines. The very objective of this webinar is to inform or make the stakeholders more informed about the process and the possible solutions if we can take it up here. So we'll start with certain questions from the panelists, and I would request if the panelists can throw some light on various issues which we have summarized, and later on we will take questions from the participants as we go forward. Sir, Mr. Malhotra, I would first like to invite your views on curtailing the power of committee of creditors to shorten timelines. We have viewed that sometimes it takes long time to take a decision, particularly a committee of creditors. Though we have seen that IBBI has given a circular which says the people who are attending the committee should be fully empowered.
Correct.
But I don't think that is possible in a hierarchy of banks where an AGM or the chief manager is attending, and it will not be possible for an ED or a GM to attend those committee of COC meetings. Now, there are two things. One is whether a possibility and what are the solutions possible in your view, and secondly, will it impact the working of committee of creditors? Sir, please.
Sure. Thank you for the question. Like I would say, I would, for my panelists and everybody here, that I'm unwell. So kindly cope up with my voice and the timeline over here. So as far as the question is concerned, sir, so in our past experience, I mean, I would correct that I also have an experience of almost 10 years in this, in practicing law. So in our past experience, as far as the timelines for COCs are concerned, so what we have watched is that the main delay is caused by the COC internally as far as their voting is concerned. So as we talk about IBC being a reform, so there has to be a reform in the hierarchy structure also as far as the banks are concerned or other financial institutions are concerned. So in the meetings, there has to be decision taken impetuously at that point of time itself in order to comply within the outer limit of 270 days or 330 days or whatever is prescribed in section 12 of the IB code. So according to me, there has to be a mechanism in light with the intent of the notification of IBBI. So IBBI in its own wisdom has faced or has has collected the issues which is all across faced by the members of the COC, faced by the RPs, and has deliberated upon that issue and come up with this notification stating that the person who should be present at the COC should be empowered and adequately empowered. By the way, I'm using the word adequately, is empowering does not mean that his presence should be there, right? He should be adequately empowered to take a decision on behalf of the entire institution. So in various cases, we have seen that on the verge of the resolution plan being admitted, or any decision of the COC which is required, correct, even for that matter, extension or exclusion or putting the company to liquidation, the average time which the bank takes these days are 10 to 15 days. And considering facts wherein the COC is, or the timeline, CRP timeline is about to expire, these situations come against the the very intent of the law, right? So therefore, in my humble opinion, there should be a reform internally also, wherein the banks should direct their or should have a formal channel through which the person coming at the meeting is adequately voted, empowered to vote either this way or that way while representing the COC. So that is the first answer to the query, sir. Sorry. And any other questions, sir? Sorry, I didn't get your.
In this regard, one more thing I would like to just share is because see, mostly all the major banks have created their stress asset management vertical or recovery verticals, where they are specialized dealing with the subject. They do not need to go to the entire hierarchy. There is a separate line of control which is there, or management is there, where they seek the approvals, etc. You are rightly saying. So one more thing in this, I would like to just ask in your views on that. See, sometimes it happens that we are already giving the RP is already giving the agenda in advance.
Right.
Now the thing is, they can internally discuss what is how it is to be dealt with, and before coming, the thing is, except for very urgent, important matters, the RP can continue to give adequate notice for meeting, and then this can be one of the suggestions where they can come up with internal discussion first before coming to the meeting itself, so that they can decide upon
right. So
at that time itself.
there have been matters wherein we have asked the COC members to be prepared in advance. Obviously, the statutory notice has to be there, wherein the RP says that what is the agenda for the ensuing meeting of the COC. But the thing is that they are well informed, they are well prepared, but they lack that adequate authority, like I said, right, to vote, because ultimately there's a hierarchy that has to be followed. So we need to reform. There has to be a reform as far as this hierarchy is concerned, sir. So this needs to go away. The person who is otherwise empowered should have the right to vote there and then. Or like you said very rightly, there are matters wherein which require certain more deliberation, certain more internal discussion, for which they can take a reasonable time. So firstly, whatever things have been done has to be done while keeping the timelines as sacrosanct, right? So the approach of the IBC should not be disturbed, or should not be left away with any point of time, be it during the CIRP by the RP or by the COC during conducting the entire process. So that timeline, that outer limit, should today be strictly construed. So there has been a mentality which I've seen, that okay, we can move for extensions, we can move for this, we can move for exclusion. Correct. So that mentality has to go. See, ultimately the corporate debtor has to survive, right? In lesser time the resolution takes place, it is better. The more time it will take to resolve, the value of the asset will be not maximized. So we have to go by the intent.
Fine, thank you. I'll come back later. You can take some rest, and I'll come back a little bit later. In the meantime, I'll take up one issue with Nitin ji. See, vetting and admitting claims, because a claim is one of the major issues of contention that we have seen in the CIRP, are challenging, particularly in case of the real estate matters, where the class of creditors are there, and number of creditors range from 200 to something like 1,000, 1,500 also. In this case, admitting the claims, creating, establishing the COC immediately. So there are a lot of challenges and the pressures from all quarters on the RPs. And that includes government also. Government means, I can tell you about claims of provident fund, claims of gratuity, claims of these GSTs, etc. There are a lot of pressures. Now, how can we ease these excessive burden on the RPs? One is the quality. Secondly is the timeline. Now I have to maintain both the things. I would, Nitinji, I would request your views on how to reduce this pressure, or how can effectively manage this.
Sure, Mr. Gupta. I think that's the real challenge about the claim, because the determination of the claim becomes the significant part of the either a resolution or a liquidation. So, as in the initial year period, resolution professionals, insolvency professionals were grappling around with this whole process of claims. And most of the time, the debtors are also, the creditors are also ignorant. Operational creditors are ignorant about the timelines, despite having a public notice being issued, despite having been put it on the website, despite giving a sufficient time for them to lodge the claims. They are not able to do it, and it indirectly affects and prolong the entire resolution plan. And how and why it entirely prolong it? Because the people who are not able to lodge the claims with the COC, with the resolution professionals, they then go to the NCLT and they give their reasons, and NCLT has to determine on the merits about each of the case independently, and it becomes a humongous task for getting the claims admitted in a particular manner. So, by and large, going back to the example, what you mentioned, the real estate is a very classic example of determination of the claims. While we are handling certain projects right now, and we have seen the home buyers being from minimum 200 to 2,000 home buyers, the collection of information itself at an initial stage is a humongous task. How it can be reduced in our practical experience, I'm telling you from our hands-on job, from the challenges which we are facing on the ground, is when we are about to file the Section 7 application. At that point in time, we should have the insolvency professional consented on board, a reputed insolvency professional. And while filing itself, maximum claims should be verified before even filing the Section 7 application. It may take slightly longer time than anticipated. But if most of the home buyers, and believe me, we feel that they will not give, but they provide you each and every document and supporting to support their claims, which are paid either to government registry or to builder or to any other home finance authority, what kind of loan, what kind of principal amount, they have each and every check balances with them. So while filing the Section 7, if these claims are verified, so one part of the job is over, that those claims will take a lesser time for resolution
Absolutely.
professional to really deal with those claims at that point in time, and the discrepancy is going to be minimal. I would not say it's 100% foolproof, but discrepancy is going to be minimal. At the same time, as you rightly pointed it out about the government authorities, disclosures, and all, to some extent, resolution professional hands are tied because they approach the authorities to get more information. It's a time consuming exercise. To start with the claim process, they only have the right is that they go back to the previous balance sheets, which are audited balance sheets, which are in the public domain, and they need to take those figures to start with. Yes, on the way, when the claims are coming, there will be some time barred claims, there will be certain disputes. So resolution professionals in a timely manner should engage with the commercial prudent, either a legal services or the services of a chartered accountants, while they themselves are a very proficient chartered accountants but an independent, to verify those claims, to ascertain the quality of those claims, whether they are time barred or whether they are genuine claims, ascertain the very supportings of those claims, so that even if tomorrow the parties go under dispute to NCLT to lodge their claim and say the figure was not X but it was X plus Y, resolution professional has done his job well, and he cannot do it himself for the entire process of verification. He need to, for a disputed claims at least, cull out those and take those opinions, so that even if matter ends up in litigation, he will have the backing to ascertain those claims. So these are some practical things which he needs to keep in mind. To answer your question was twofold on the quality. One, I have addressed regarding the quality of the claims, how he need to address upon. As far as the timeline is concerned, one or two things which are not under the law, but they are evolving it in a very rapid manner, and they should continue to do, is to use the technology for larger claims, to have the Google Forms, to they have the information uploaded on the digital platform, to verify the information through a platform, so that the method in which they collect the information is synchronized and the method in which they process the information, whether with the resolution plan or liquidation, remains with them forever. Because sometimes these companies, when they go into resolution plan, these information becomes significantly critical, on which the resolution professional, he is a professional at the end of the day. He doesn't know what the company has done in last 50 years, 80 years, 60 years. So this information repository collected in a symmetric and a chronological synchronization manner helps in a long way to go to process these claims. So these are the two things to address as far as the resolution professionals are concerned while dealing with the claim theory.
Thank you, Nitinji. Another question related to is that, do you think the powers of the resolution professional should be enhanced? Because there is wide range of responsibilities. He is responsible for everything. But we feel that, do you think as per the law, the powers should be enhanced so that he is more effective and he is able to take timely decisions and then execute the entire plan or entire scheme of either resolution or liquidation in the time bound manner as prescribed by the law? Even if we think, yes, whatever times have been prescribed are fine. So, what is your view on the empowerment of the resolution professionals?
See, you have put a question which cannot have a yes or no answer, because it's an extremely debatable question, and it is like a two sides of the coin which cannot meet at the same time. So powers, while at the same time, has to be as wide as possible to bring the resolution to the speed to them. But at the same time, more powers given it to them. We already have a quasi-judicial authorities. We have tribunals in place. We have the competent authorities. They are also having a fiduciary duty where they have a lot of powers given already to them. The more powers if given, and if they are not judiciously exercised, that may also bring certain kind of challenges for the company. And there is a IBB code, there are guidelines which are given for each professionals, and day I am seeing that more and more insolvency professionals are getting registered and coming into this field and in this upcoming arena. So power is a very subjective matter, and unless there is a specific need of giving any kind of powers which are already being there with one of the authorities, I would say it will become a more overlapping authority and it will lead to dispute situation. So if, for example, the power of extension of time limit, it looks to be a very procedural in nature, and if tomorrow the insolvency law committee or the committee decides, the standing committee decides that this power of timeline is more procedural in nature, and instead of keeping it with NCLT, it can be delegated, it can be subdelegated to the resolution professional themselves, then they may consider it to remove from one side and give it to the other person, but it should not have a dual power delegation, because it leads to a conflict situation. But at the same time, resolution professional, no man can be judged to in his own cause. He will get affected with that principle. So he cannot have a power to decide on his own. Similar way for fraud related cases, siphoning related cases, there are judicial authorities, there are criminal procedural codes in place to take care of those aspects. So to some extent, this power is a very judicial phenomena, and a very judiciously should be given to exercise. And wherever we are facing the challenges by the insolvency resolution professional, those power need to be assessed whether to be delegated or should not be delegated, keeping pros and cons in mind.
I think it was very well articulated, Nitinji. And the power has to match their responsibilities, and there cannot be any overburden of anything, because anything in excess leads to conflict, number one, and secondly, it also leads to the dissolution of the very objective of any purpose or any act which we are doing. I'll come back to you, Nitinji. Khushbuji, I would like to have, see, there is a limit of 180 days first, then 270 days, and then the last limit is 330 days, particularly in case of the CIRP. In your experience and in your view, is this practical? Is this unrealistic, or do you think yes, it is achievable? Uh, I would like to have your opinion on that.
Yeah, sure, Mr. Gupta. I think before I answer that question, I would like to just bring in, some stats from US, where the law is not as prescriptive as in India when it comes to timelines. And Chapter 11 has been in existence for more than 35 years now. So if I just look at, more than $100 million, asset size cases, what we see is that after 2015 or 2014-15, the average duration of bankruptcy in US has come down to 6 to 7 months. And one very important reason behind that is the advent of prepackaged insolvency even in US. So there are almost 20 to 25% cases which are prepackaged. And if I look at even more larger cases like more than 500 million assets, then the case percentage rises to almost 40%. But having said that they are able to resolve in 6 to 7 months, there are cases in US even which takes more than 4 to 5 years as well. And these are complex large cases, leverage buyout transactions, where there will be numerous secured unsecured lenders, or there could be complex litigations between the creditors and some intercreditor disputes. Now coming back to Indian bankruptcy code, and if I look at the data which was being published by IBBI, so almost 3,400 odd cases have been closed so far. But what is interesting to note is that almost 40 more than 45% have ended up in liquidation, and it's only 14-15% of them which have been resolved, have got a successful resolution. The number is around 480. Now, out of this 480, which has got resolved, there are 133 cases, or maybe slightly more than that, which got resolved within 1 year. So even in India, we do have, cases where, things are getting resolved within 1 year. Out of these 133, there were 27 odd cases, which, where the size of the bankruptcy was more than 500 crores.
Right.
So I'm just trying to say that, there are enough and more cases which are getting resolved in less than 1 year. So I would not say that it is very unreasonable to expect that the cases can be resolved within 1 year. The challenge, which, you have said multiple times right now, even on this webinar, is the challenge which we are facing is the speed of the judiciary. I think, and my panelists have said that, you have said that multiple times, that the challenge is not with the code, but in the implementation, where we are facing issues is with the judiciary. And we are just talking about the resolution timelines. I think the bigger challenge these days is to get the case admitted in the first place, which is outside of this whole timeline. And then after the NCLT has ruled, then there are several appeals which are being made, and that is where we are facing the burn. So I don't think it is unreasonable. I think their steps need to be taken to bring some more life again into IBC, I would say.
Yeah. Thank you, Khushbuji. Coming to Karanji, I think a very pertinent question has been raised by Khushbuji, that the admission of the claim. Karanji, we are really finding it that the admission of claim is taking humongous time. We have received a consultation paper which says there are cases where more than 650 days has been taken for admission.
Right.
Now, this is something which actually, in my view, defeats the very objective of making initiating a process.
Correct.
If you lose to more than 2 years to initiate a process, and then it will take another year, which is defined year, I'm not saying undefined year, a defined year which will be taken to complete that process. Now, practically we are losing 3 important years. The value of, and see, during this period, we can also find that the promoters may do whatever acts they can do, because they know that the initiation has already happened. They can siphon off a lot of things. So in this view, what is your view on how to enable the faster admission of the cases?
Sir, I mean, this is actually a practical problem that is being faced by all the profession, I believe, all across India. Every NCLT, every lawyer is facing this problem to have their claims admitted at the to have the case admitted at the earliest. I believe for a longer point of time, sir, the appointment of judges was a big issue. Recently in NCLT Delhi, especially, we had few appointments done, but still there are 6 benches, out of which all of them are not sitting as I mean fully as on date. There are benches which are still being heard by a different bench, and we are getting dates upon dates, right, sir? So ultimately, we need to see that there should be more judicial appointments. Tribunal reform should be there. Supreme Court has been time and again, apart from NCLT, also other tribunals also, the vacancy is I believe it's an inherent issue which our entire country is facing. This needs to be resolved. There needs to be more robust tribunals, and there should not be any vacancy. In fact, there should be more NCLTs. The intent of having NCLT in various jurisdictions was this only, that we had NCLT Chandigarh, we have NCLT Jaipur, so that the burden is less and the admission can take place on a faster note. But I believe that has been an exercise in futility, since the appointments have not been done to meet that level. So today we are actually facing a lot of issues, and I believe it is the easiest way out would be to have more judges and more time for the court to hear our cases. And as far as admission, there were instances taken by the court for filing of IMs, right? This thing. If there is a default, you have to file the report with the NCLT, so that the default or the trigger is automatically established at the filing of the petition itself. And in fact, if you see the Supreme Court judgments and all, especially in Section 7 cases, right, there, I mean, it is the easiest case to admit. There has to be a debt, there has to be a default, there has to be a Section 7 financial debt.
Yeah.
So there are only 3 triggers involved in it, right? So Section 7, yes, it takes, fairly less time as opposed to a Section 9, wherein you have to go into the dispute. So I believe the NCLT has been, foisted with this job, and for that matter, NCLT today is, according to me, going into a wrong direction of being an investigative body also, as far as disputes are concerned. Courts are liking to hear whether there's a dispute or not. See, it has to be. The Mobilox judgment is very much clear that it should not be a moonshine. So the court should ordinarily just stop over there, right? They should not dwell into a lot of issues regarding dispute. So if they feel there's a prima facie dispute, they should, leave. Set aside the petition. So Section 9 petitions are also taking a lot of time, because the court is taking upon itself to adjudicate the dispute, which otherwise it should not. So this is a practical, experience. In our practical experience, we have watched this thing all across NCLTs, that this practice is going on. They are delving deep into the dispute, which otherwise should not be there.
Even for financial credit under Section 7, if you see, I think you rightly said that the triggers are 3. Now,
Right.
If these three triggers are met, I don't think it should take more than 1 or 2 hearings and to close the matter. Maybe 3 hearings.
Right.
Because see, the triggers is already available with the court, and they are particularly they are well informed petitioners, I can say,
Right.
who are actually making the petition for under the law. So in this case, because if they take time, see, that's why I'm saying there are two-pronged problem. One is the promoters get enough time because they can prolong the process. They know that they can prolong the process for whatever reasons.
Right.
And once the process is prolonged, then they have enough time to do some acts of removing the things and correcting the things and all that.
In case of the corporate data, they do everything to feather.
Exactly. So my point is, I think the point that we are harping upon, some active action has to be taken by the judiciary,
Right.
to close this, particularly remove these impediments for admission, particularly under Section 7 application.
Under Section 9 will take time, because I mean, to put a company into the rigors of insolvency, there should be a clear-cut case, right? But as far as Section 7 is concerned, all the triggers are made out prior to filing the petition. So therefore, the only trigger should be seen and immediately. So the Supreme Court in ICSC judgment was very much clear. It says that NCLT need not to see anything beyond these three things, correct, sir? So therefore, the tribunal should also limit itself to only those triggers and not go beyond those things. I mean, on technical aspects especially, which are taking a lot of time.
Yeah. Thank you. Khushbu ji, one more thing which we were harping upon or we were discussing, the availability of information seems to be biggest impediment in the running the process. Now, if I have to prepare an IM, if I have to admit the claim, if I have to file an proof application, or whatever I have to do, if I have to determine any, make an opinion on the proof transactions, see, information is not there. People are controlling those information. They have either destroyed or they have removed from the source. They are not sharing the information. Now, do you think in this case, not only the Section 19(2) is already available in the court, but do you think some more stringent clauses or some more stringent penalties should be levied on the promoters, auditors also? Because we are observed that auditors are also not cooperating to the extent required, because they have the information, they have the balance sheet, they have the Excel sheets of the balance sheets, but they are not sharing for reasons best known to them. We are not into that portion. And I'm also seeing that in the recent discussion paper issued by the IBBI, they also pointed out these impediments. So I would like to have your views on more stringent provisions in the law, particularly with respect to the directors, auditors, promoters, and the employees.
Right. Sir, I do agree completely with you on, this challenge, but I also feel that, the part of the answer is our, lax corporate governance in general in India. I think it is not just like in IBBI that, this is the issue. Sometimes, in fact, in some of the cases, and we do work on mostly large cases, and even in large cases, we have seen the information doesn't exist or exist in a form which is not readily usable. So we can't say that the information is not being provided to us, but unfortunately the information which is being provided takes time to sort of synthesize. So in this situation it becomes a little difficult to prove that people, directors and maybe ex-management, existing employees are not helping us resolve the case. And if you ask me, see, there is a provision which is applicable, as you rightly said, Section 19(2), and which prescribes that if there is a situation where RP feels that the information is not being provided or some person is becoming an impediment to the process, RP can go to the court, and court can give punishment under Section 70, which does have imprisonment of 3 to 5 years and fine or fine both up to 1 lakh, or sorry, between 1 lakh and 1 crore. So I think there is enough provision, but as we have seen that there are actually not many applications also under this Section 19(2), because it is very difficult to sometimes prove that in India that whether someone is trying to hide information, because in some cases genuinely I have seen that the information management itself is quite poor. So it's like I would not say that it is just IBBI. I just feel that having more stringent law would definitely help, but on the other side, as Mr. Nitin was saying, right, that there are two sides. So it will just become onerous also, I feel, on directors and ex-management, and for possibly no harm of theirs. So in my opinion, I don't think that there should be any more stringent law. I think we have the provisions in the code which are not being utilized at the moment. Is what my opinion would be.
There is a link to this question. See, in case 9, I have filed a 19(2) application. Now I am seeing that gets lingered on for quite some time. That is not being heard on priority. at one point of time, I have, as an IP, I am required to provide everything on time. I am finding that there is a resolution that I can bring in for by whatever means I am there is there, but my IM cannot be ready. It's not prepared because of the lack of information. Do you think at least if no further legal provision is required or to be made stringent, can we at least prioritize these 192 applications to be heard on priority so that the information comes forward in a faster manner and people are actually taking the things seriously? Yes, the
Absolutely.
information is very, very critical. So
Yeah.
what is your view on that?
No, absolutely, totally agree with you, sir. I think I feel that there are enough provisions in the law, and if let's say there is an application under Section 19(2), you have rightly said that that should be prioritized, because an RP cannot be held responsible if the RP is not able to receive information. And there are, in past, NCLT has taken favor in favor, given judgments in favor of RP. Like can recall one case, Educom, which was, RP had filed that he was not able to receive information on time, etc. And the court has taken, RP's side. But yes, absolutely, that unless there is a hearing, this cannot be resolved. So it should be prioritized for sure.
Yeah. Thank you. Nitinji, I'll just like to come to you. See, during this process, either in a CIRP process or a liquidation process, we are seeking various directions from the court. That includes assistance from local administration, police, for taking possession of the assets, and various directions we are seeking. And definitely it is a time-consuming process. One is the courts are overburdened by the application. As more applications I am filing, more hearing have to have there, and definitely the courts are more burdened. Already more burdened, courts are further burdened by these applications. What do you think when there is a CIRP starts and in a single application, can we make some change where the RP says, see, these are the areas where I would need assistance, and an omnibus sort of order is given, rather than having a direction of for each in each case I should approach that for this particular police station I need this order. Because this is one of the cases where we are finding, I found in my case, where we started taking a possession of an asset. The relevant concerned police station said, I need the order in my name. Now, so if we say, okay, there are the assets and these are the jurisdiction where we are required to approach, we may be required to approach, kindly give us an omnibus order, because now in any case we are a quasi judicial authority, we are a court officer. As an RP, I am saying, so I will do whatever is correct on my part to do justice to the plan process. So I would seek your views on that, sir.
So, Mr. Gupta, yes, this is the common problem which is coming nowadays from RPs as to the preservation of the asset, the disposal of the asset, and the collection and taking the charge of the assets, so that they can continue to maintain the at least value of the assets. So, having said that, I would just like to reiterate some of the principles which have been established well in SARFACI Act from the DRT jurisdiction, where all this was always a common problem from the banks. And banks today are very seasoned to deal with those problems, because for them it has become a very routine, automated process where they know that if it is an open land, if it is a factory, if it is a commercial space, how to go about it, what notices to be issued, which courts to go, how to take the possession. And it has become a very seamless process. You will not see a much of a noise if bank is going through a DRT SARFACI process to do the auctioning and process and taking over the possession of that, because that has lived its life, that has seen those challenges. It has now become a process in itself to take those possessions and those auctions and to take the charge of those properties. Now coming back to NCLT, for RPs, this is a slightly a challenging task, because while RPs themselves are not having the powers to do so, at the same time, they are heavily relying upon NCLTs by filing separate IAs, and those IAs take time to hear. By the time the assets values get deteriorated, and there are a lot of challenges which come by creating a third party rights, etc., etc. So what are some of the best ways to do it when it may be a cumbersome and a difficult process to have a one consolidated application? What is the common challenge which is currently coming into courts right now is, under each of the insolvency application, there are more than 20-30 interim applications which get tagged. One may require attention of maybe 15 minutes, the other may require attention of 2 hours. So, and these 20 matters, interim applications are tagged and shown as a one case only. So to my mind, if tribunal honorable judges are to hear that one case, one case is going to take the entire day. So such kind of a humongous application where there are orders on PUFE, orders on restrain, injunctions for sale or taking possessions, or order to police authorities require multiple applications are filed. Beyond certain numbers of applications, courts should have a special tribunal member sitting to hear at least those particular cases which require attention on a specific given date. So the whole company, because if they hear 2 application and if they don't decide the other 10 application or 15 application, the entire company suffers. The resolution professional is still stuck, because what happens in 1 or 2 relief, it does not really give a result to the resolution professional to resolve the company or to revive the company basically. So such kind of a large cases where there are multiple applications filed by both sides getting tagged should be heard and given a special attention, so that RPs can then take the direction timely from the court and can accordingly act upon those directions, or direct the third parties authorities who can then act timely to assist the RP to do the needful.
Thank you. Coming to the PUFE transaction that you have raised, see, we have to file a PUFE transaction in a time-bound manner. And in a lot of cases, we find that the accounts either are 4-year-old, 5-year-old, even 2-year, 3-year-old. The accounts are not available. In the absence of detailed accounts, detailed information like Tally or in Excel, the flow of various heads of accounts, particularly personal accounts, it becomes very, very difficult for any RP to first make an opinion and then determine. The transaction auditor always also face similar problems, similar headwinds, because they don't find available information adequate to make an opinion or make a determination on that or give a report. Now that definitely leads to delay. So what I would request your views, that how to curtail these type of delays or how to address these issues, particularly in the matter of RP, where he is subject to various, I can say, the regulation by IBPI, by the IPA, as well as sometimes they are also asked by the court itself, okay, why you have not filed the application under PUFE and all that. So I would like your opinion or your views on that.
Sure, Mr. Gupta. So regarding the PUFE transactions, basically the regulations quite support in terms of timelines, that 135 days under the IBC corporate personal regulation, where regulation 35A provides and enables that if RP comes to know later on, they can still go ahead and file for an application for PUFE transactions. But yes, you are absolutely right that PUFE transactions are something which doesn't come, RP may come to know, and he may have some access only by third party informing. The books may not be clear. So to my mind, my views on this directly links to what government has taken an initiative, which itself is a debatable. Some people are in favor of the thresholds which are being posed post-COVID, and some people are not in favor of those thresholds. But that significantly reduce the burden on the courts. So like 1 CR is the operational creditor threshold which has been imposed. basically, which has significantly reduced the filing of the applications. Good or bad, I would not comment. That's not the current question you have imposed on me. As far as the PUFE transactions are concerned, the authorities, the resolution professional need to first see some iota of a doubt in terms of a fraud, because fraud is a very, very serious allegation need to be put in. The siphoning of fund, the fraud, just because accounts mismatching cannot always become a intention of fraud. And that leads to a confusion for tribunals also to spend time and see, because tribunals are not an authority to determine the fraud and element of fraud. That is something will be determined by the competent authorities. So the element of fraud needs to have some higher level of threshold to determine the fraud related application. There should be some de minimis threshold for those applications, because otherwise courts are getting clogged. The RPs are also, if they do not file, they will be under the violation of their fiduciary duty. If they file it, they are creating a more and more applications which may not be really required to be heard. So, for example, if there is a reconciliation issue, or while it amounts to fraud, fraud is again, I'm saying, need to have a very heavy test of fraud. But if there is a mismatch of 5 lakh rupees or 15 lakh rupees for a company which is under resolution worth 15,000 crore company, is it really something for which you need to file a transaction? Is the question one needs to answer. So this need to be deliberated by the detailed committee from various experts to see whether the thresholds can really help to de-minimize the PUFE transaction and give more importance to the critical ones. The second one is put the proper test of PUFE transactions, some more detailing around it, because the definitions are extremely wide enough, which is rightly so, to cover the promoter in every sense, so that any and every transactions done by them through a connected person, through a related party transactions, all sorts of things, undervalued transactions are covered. But that needs to get filtered it out at the RP level, where RP should not be responsible, but should have a yardstick or a benchmark, so that he can reduce those PUFE applications and can only make those applications which are significantly affecting the value of the company.
Thank you, Nitinji. It was well placed reply. Khushbuji, I would like to just point, because we are very close to our end of the session. One last question I would like to ask. See, there are delays and in the decisions, delays in processing. One applicant has made an proposal to the committee of creditors, which they take their own time to approve, first of all. Then it goes to the court. They are taking their own time for whatever reasons. I'm not going into the reasons, but they are taking their own time to give the orders. That particularly, I am finding that it frustrates the very purpose of taking that asset. The value of assets in their consulted opinion goes down significantly during this period. They lose interest. But once they have put a proposal, they cannot withdraw. Otherwise, what happens that they have to get their EMD and security deposit forfeited, which is significant amount that they are depositing at initially. Now, do you think, in your view, should they be allowed to withdraw in such conditions, and what are such conditions where they may be allowed to withdraw from the process, though it may ultimately affect the creditors also? But see, as a investor, I should not be held responsible for the delays that is in the process.
Right.
I would just like to get your opinion on whether they can be allowed to or forced to continue, or can be allowed to withdraw.
Right. No, totally, I think bang on question. So I don't think that, anyone here as part of panelists or listeners wouldn't deny that, the investor appetite in IBC has, definitely gone down. Mainly because that, that promise of timeliness has not been met since the inception of IBC. And one of the biggest reasons is judicial delays. And of course, there are process delays as well. And to answer this question, I would draw from US Chapter 11, and though the modality is completely different, the process there is debtor in possession. But assuming if let's say we sort of compare the debtor with a successful resolution applicant in case of IBC. In US, and I'll just quote that section also for our listeners, is that in under section 1127 in US chapter 11 and rule 3019, the debtor reserves the right to actually revoke or withdraw the plan at any time prior to the confirmation date. And once that confirmation date passes, the plan is null and void. And during this process, debtor also reserves the right that in consultation with the committee of creditors, the plan can be modified or altered. Now I think if we draw some from chapter 11, I think we should be allowing the resolution applicants to withdraw or modify. Now how we do this can be debated. There could be multiple ways. So either it can be different for each and every case, or there could be an outer timeline, let's say 6 months, 8 months, whatever we feel is a justified timeline. But one suggestion could be that when the RFRP is being laid out, do we give a timeline? Does the COC give a timeline saying that okay, if the process delays beyond this date, then you will be able to withdraw? And here again, I think one most important thing is that the NCLT should honor the commercial wisdom of COC in case the plan does get withdrawn or changed. Let's say it gets modified after that particular date. NCLT should honor the commercial wisdom of COC, that if COC is agreeing to that modified plan, NCLT should approve, and rather than hearing to the frivolous applications which are then being made from let's say the competitors who had bid in the first phase or the promoter, etc. So I think definitely something needs to be done. Some timeline need to be provided, because if we do provide, I think there will be renewed investor interest, because right now people
Exactly. This I think.
yeah, people
I feel that
they have no option.
amount of sorry. I feel that once this happens, there will be more number of resolutions, because this is a deterrent to investing.
Yeah,
a big deterrent, because I know that my money will be stuck. I'm finding that in some of the cases, people are saying, see, I don't know when my money will be available to me. So I
right.
cannot be continued to hold this money till eternity. So you have to allow me some time. And I think you well articulated the reply, and it's well taken. If there are any questions from one of the auctioneers, okay. If there are any questions from the attendees or the invitees, I would take those questions. Okay, right now I don't have any questions. I think we'll conclude with this webinar, and it was a great learning and great understanding. Not only the Indian law, I think Khushbu brought a very good flavor of US law as well to this webinar, and we are privileged to have the learned panelists here, and they shared their experience and also their wisdom with us. Thank you, Karanji. Thank you, Khushbu, and thank you, Nitinji, for this great session. And we look forward for further such sessions sometimes later. And at appropriate times, I may also bother you for such session, because we plan to have similar sessions later on as well. Thank you very much.
Thank you.
Thank you, everyone. Thank you, all the participants. Thank you, the esteemed panelists, and Mr. Gupta. Thank you very much.
Thank you, everyone. Yes. Thank you.